Okay, we're at 9:02, so I'm going to begin the webinar so that we stay on course here. Just a little background introduction. Thank you all for joining us for the webinar today. My name is Joan Popolo, and I'm the Executive Director of Action Innovation Network. Just a little background on Action. We are a collaborative network of technology business incubators and other entrepreneur support organizations that are based throughout the greater Boston and throughout New England area. Our network supports startups developing technologies in the industry sectors of the life sciences, clean tech, robotics, ocean, marine, and maritime, and advanced materials. We provide a suite of resources for international startups that are looking to explore the Boston innovation ecosystem as a place to grow their company in the U.S. So this webinar is the third in a series of 5 annual webinars that we present on topics of interest to international startups as they look at Boston and the greater Boston area as a place to grow their business. Just a couple of housekeeping items before we begin. All attendees will have had their audio and video muted. The presentation itself will run for approximately 45 minutes, after which we'll have about 15 minutes for questions and answers. So I would appreciate that you hold all of your answers until the end. We do have a chat box here at the bottom. You can type in your questions that you'd like presented to Brian. The webinar will be recorded and posted in a couple of days on the Action website for future viewing if you have to leave the webinar or if you want to view it again in the future. So today's webinar is called Massachusetts Employment Issues for Foreign Employers and is presented by Brian Mullen, an attorney at Bowditch & Dewey law firm. Brian is a highly skilled and experienced lawyer with Bowditch & Dewey, concentrating his practice in labor and employment law. He represents his clients in the full spectrum of labor and employment litigation matters, including wage and hour claims, discrimination actions, non-competition and trade secret disputes, and contract claims in state and federal courts, in arbitration and mediation, and before state and federal agencies. He has extensive experience drafting policies as well as all matter of employment-related agreements, including employment compensation, commission, confidentiality, non-competition, and separation agreements. So with that, I'm going to let Brian launch into the webinar.
Thank you, Joan. Good morning. I provided a brief agenda for the program this morning. One of the things that I'd like to let you know about how I go through these kinds of programs. First is that I provided you with the materials in the webinar with a good deal of base information that you can refer to, basically topic areas as well, and I will discuss all of those. And if you have particular questions at the end, be happy to answer those that I can. But I'll follow along with this topical agenda, and you'll have this for resource going forward. I think the first thing that the clients want to know who are coming in from other countries to the area is basically the nature of employment in the United States and in Massachusetts in particular. In Massachusetts, there is a presumption of employment. This means if you have people who are working in what's called the gig economy or independent contractors, or you're going to have folks helping you or assisting you to start up or to help your business emerge, those folks are going to be presumed to be your employees in Massachusetts, with limited exceptions, which I'm going to talk about. What that means is once someone is your employee, you're responsible for compliance with all employer requirements as to each employee. This includes, appropriate paying for appropriate work and hours, for safety conditions in the workplace, for providing statutorily required benefits, for complying with contractual obligations, everything that would normally come with having a person in your hire. Again, this can include pay and benefits as well. In Massachusetts, even though there's a presumption of employment, there is also a presumption of employment at will. Employment at will simply means that the individual and the employer are free to end the employment relationship at any time and for any reason. That means that an individual can resign and the employer has no recourse if they do so. And the employer can choose to terminate someone's employment for any or no reason at all. The employment relationship, as we're going to talk about, is obviously modified from employment at will in several different ways. One is by employment contracts, which would need to be followed, but also by other limitations under public policy. Public policy limitations essentially are a restriction on being able to terminate someone without recourse. In other words, a person can come back to you for benefits or even claims under law if you terminate them for refusing to break the law. If an employer, for example, would ask one of its finance officers to falsify reports to the Securities and Exchange Commission, that would be a crime. If the individual involved in that, the individual employee, refused to do it and was fired as a result, that would be a firing in opposite to public policy, which means that that individual would have recourse to sue the employer for an improper firing or termination. You also cannot terminate someone for doing what the law requires. So if, again, someone is making required financial reports or reports on government contracting, things of these nature, then if the employer were to try to stop that person from complying with the law and terminates them as a result, again, there would be recourse for that termination. And finally, the third public policy limitation is that you cannot terminate an individual for asserting their rights under law, for things like to be free of discrimination or harassment in the workplace. So if an individual files a claim against the company for allowing a hostile environment to exist, which we'll talk about what that is, and it rises to the level of discrimination, they could not take adverse action against the employee for making that claim. The same goes with workers' compensation insurance for having a work-related injury or illness. An individual has a right to file for benefits where they are injured or become ill as a result of their work. And an employer cannot terminate them or take other adverse action against them for doing so. Independent contractors, this is a significant issue, particularly for startup and or emerging companies. Many times staffing is an issue, budgets might be an issue, or the need for short-term help is an issue. And companies or employers will engage individuals they believe to be independent contractors. Independent contractors are seen as being individual or small groups of entrepreneurs. In other words, people who are actually in business for themselves. They are not dependent upon the employment that they receive from the employer or the company, so to speak, in that they would continue to be in business and that they would exist absent that relationship with the employer. There are, in the United States, one of the things that is very important to remember is here we have federalism. I have clients from Europe that it's sometimes confusing to them that there are different strata of laws and regulations based upon the federal law, which covers the entire country, as well as state law. In the United States, federal government can issue laws related to employment issues, such as wage and hour law, and states can as well. However, states can only make greater the protections of federal law, and can add regulation and law in places where the federal government has not done so. If there's a conflict between the two, in general, the federal law will control. But for example, in independent contractors, in determining who is actually an independent contractor, or whether the individual, it would be seen to be an employee for which the company would be responsible for. On the federal side, the IRS has a 20-factor test, which there is no one factor is controlling, but ultimately what that test gets to is who has the right to control the individual. If the employer has the right to determine the time, the place, and the manner that the work is to be performed, then that individual would likely be considered to be an employee. The federal test is less stringent than the test in Massachusetts. In Massachusetts, there are 3 elements, which I put here in the slide, that the employer has the burden of proving that the individual is an independent contractor. An important note to make is that it doesn't matter whether the individual wants to be an independent contractor or does not want to be an employee. This is an application of law. So even if there was an agreement between the company and individual that they should be an independent contractor, that agreement would be null and void unless the employer can demonstrate that these 3 elements have been met. And the first is very similar to the IRS test that I mentioned a moment ago, is that the individual is free from control and direction in performing the services. In other words, you have someone that has a particular set of skills that you don't have within your organization, that you need them to apply their professional experience and judgment to complete the task. I always use a simple example for people. I say, I'm a lawyer, I'm not a plumber. If there's something wrong with the plumbing in our offices, I call a plumber, someone who's has their own small business or their own business, and they come in and they know about how to fix pipes and how to make water run the right way. And I don't tell them how to do it. I just tell them that they need to do it, and I've engaged them for it, and they then send me a bill. That's the purest example of an independent contractor. It's someone that has nothing really to do with the necessary aspects of my business. They're not going to be going to court, but they're providing a service to my business that I need to have done. And they are doing it, they're holding themselves out to the world as being a plumber and providing those services to others as well. That's how we get into that's an explanation of these other elements as well. Again, as I described, the service a plumber is performing is outside the usual course of the business of a law firm. And the plumber is customarily engaged in an independently established business or trade. And he holds himself out as providing those services to the world at large. So I'm not the only person he's ever going to provide plumbing services to. He has advertised and he has done other work. Just a quick note on a couple of other categories of folks that employers tend to get in trouble with here. The determination of whether an individual is an employee applies also to individuals such as interns, individuals who are in a college or trade program that you want to bring in for a summer or for a short period of time to perform some services for your organization. May very well be employees under the law. The only exemption there is where an individual is actually part of or participating in a bona fide academic program, and the internship is essentially an element of that education. So again, from a law firm perspective, is we bring in summer associates in the summer season, who are people who are in law school, and many of them are required to get these internship positions in order to learn more about the practice of law, and they get credit for it at their schools. Because of that, it's an educational process, not an employment process, and they would not be considered to be our employees for the most part. People who volunteer for you, only not-for-profit organizations can really have bona fide volunteers. These are individuals who understand and agree that they are engaging in some service for a not-for-profit organization out of their interest or for that organization, or a desire to assist in some way. And they understand that they are not going to be paid, and they do not expect to be paid. Graduate students, much like interns, many times graduate students, because they're doing things like teaching and research, can be considered to be employees. Employment status and hiring, I've just picked some basic points that need to be focused on for, again, new or emerging businesses in Massachusetts. You want to employ a structured recruitment and hiring process from a legal perspective to ensure that you are meeting all compliance requirements, both state and federal, in hiring. And I'm going to talk about some of those. And also making sure that you don't engage in conduct in the recruitment or hiring process which may expose you to claims for violation of law or discrimination. And that's why I say to all of my clients is that they really need to have a process from advertisement through to completed offer that has individuals in it who are trained and understand some of the base requirements of the law, particularly issues concerning discrimination. Those issues concerning discrimination we'll talk about more particularly towards the end of the webinar, but in general, there are several protected categories under law, both federal and state law, such as an individual's color, their race, their religion, their national origin, disability, their status as a military veteran, their marital status. All of these things are individual characteristics of a person that cannot be taken into consideration as the basis for an employment decision. Doing so could subject you to claims for discrimination and significant damages through administrative agencies and or through an individual lawsuit brought by the candidates themselves for damages. The best advice that an employer can have is that anything that you do in your employment process must be directly related to the job. For example, all your questions should be about how an individual that has the background, the skills, the education to meet the requirements of the job. Whether or not someone has children, whether or not they're married, whether or not they're gay, has nothing to do with whether or not they can provide the service or have the experience in order to perform the job effectively. I strongly suggest that you have a written application. Applications are not only a good administrative vehicle in that they give you a lot of base information about individuals, such as references, their contact information, and you make sure that you have all of that. But you can also provide notices to individuals through an application about the process, about the nature of employment, and also any continuing obligations they may have. In other words, asking an employee on an application to disclose whether they are party to any contract which might limit their ability to perform the job for which they're applying. In other words, they are leaving an employer, they already have an employment agreement that says that they can't go to work for you. You want to have that information disclosed up front, early on in the process if possible, so that you can evaluate whether that obligation is something that would impact the individual's employment with you, and also whether or not hiring that individual might subject you to claims from the former employer for interference with that contract. Background checks. Most employers that I work with do some form of background check. A reference check is a type of background check. One of the things that I put into applications is a notice concerning a release for prior employers or others who are listed as references to provide information to the recruiting employer, so that here, particularly in Massachusetts, former employers and references are far more likely to give you a clear and or total reference of a person's performance if they know that there is a release that has been signed, whereas the person on the application has released those people from any and all claims for providing truthful information. There are other kinds of background checks that many of my clients use, particularly those in high tech and in biosciences, is they actually want to contact universities and colleges to confirm educational experiences. It's not just a university written down on a piece of paper and a resume. They want to be able to contact the university and to have a release from the individual, which will allow them to look and actually see their course of study and certificates and their particular degree. That's all allowable in Massachusetts and the United States. Where regulation comes in is if you're asking questions about things like criminal history. There are restrictions both in federal law and state law in doing so. In Massachusetts in particular, you cannot, on an application or at any time prior to an actual in-person interview, ask an individual about anything about criminal history. And then, if you are going to ask them information about criminal history, there are very, very limited questions that you can ask. There are limitations on what kinds of crimes you can ask about. There are limitations about how far back you can ask an individual about their criminal history. That prohibition is about asking the individual. Where employers want to know more, many times they'll hire a third-party vendor to do the research, to go to get the public records at the different courts, so long as a proper release has been signed by the candidate. That's absolutely lawful to do, and you have not asked the individual for that information. So you're not technically not breaching the law anywhere, as long as you've complied with the requirements of the FCRA, which I say here, which is the Fair Credit Reporting Act, and that you have to have a release from the individual, a knowing release that you're going to be searching, doing that kind of background check, and that you're going to use a third party, that they will have a right to see a copy of the report produced by that third party, and have an opportunity to correct anything they think is wrong or inaccurate in the report before you make a final decision concerning their candidacy. So those are just some of the basics in hiring up front. On the recruitment and selection, documentation is always the next piece in the process. You want to have, although it's not required, I believe a great vehicle for making sure that everyone is clear on the obligations of employment is to have a good written offer of employment or employment contract. Okay. Setting forth the basic terms of employment so there is no argument later on down the road. In other words, things such as whether or not an individual was going to be required as a condition of their employment to enter into a non-competition agreement or an inventions agreement, or that they were going to be required to travel 80% of the time. Those are the kinds of things, when they aren't documented, become the impetus for arguments and potential legal actions when and if the employment relationship sours. You want to be very clear about their status. Are they an at-will employee? Do you believe that they are an employee with a contract for a term of years? In other words, that you have entered into a written contract with them that says an individual will be employed with you for 4 years. If you enter into such a contract, then you have to honor it. And if you don't, you could be subject to an action for breach of that contract. And that is in contrast to an individual who's in employment at will, who you can terminate or they can quit at any time. Pay and benefits, you want to be clear on what you're offering, as well as things that may be available at some point, but also to reserve your right and make clear that the company, again, reserves its right to change and to modify benefit programs. That way you don't get into an argument later on as to whether there's a contract for a certain kind of medical benefit, for example. And again, you want to let people know that they are obligated to you if you're going to require any restrictive covenants. Restrictive covenants, many of you are probably familiar with these. There are non-competition clauses which prevent individuals for a period of time from leaving your employ and going and working for your competitors. Non-solicitation, similar kind of restrictive covenant, except it doesn't prohibit someone going to a different employer. It prohibits them from, say, soliciting your vendors, your clients, and or your employees to end their relationship with your company. Forfeiture for competition clauses in agreements, which is that an individual may be receiving stock options or some other residual financial benefit that they would forfeit should they violate a non-competition clause. And the reverse is a compensation for non-competition, where someone is going to receive pay for a period of time that they are not, that they do not compete. Massachusetts, about a year and a half ago now, for the first time codified in law requirements and limitations on non-competition agreements. This was something that was in debate for almost 10 years. As some of you may be aware, there are some states in the United States that do not allow non-competition agreements at all, California being one. In Massachusetts, we have codified by statute a basic rule that a 12-month non-competition period following employment is acceptable under certain circumstances. And one of those circumstances is that the individual be paid a period of what is called garden leave. In other words, paid for at least half of their pre-termination salary or equivalent pay for a period of, for the same period as the restriction. So if you had someone on a 12-month non-compete, you would wind up paying them the equivalent of 6 months of their pre-termination salary over that period. In order to support a non-competition agreement as being valid under law in any circumstance, you can't be protecting your company from ordinary competition. There has to be a good basis in law for the restriction, and that is you have to be protecting your confidential or proprietary information or trade secrets, or protecting goodwill, including your customer relationships. Goodwill in Massachusetts is seen as the typical example or a simple example is in either a CEO or a salesperson, where part of their job, or anyone who has a part of their job, is to go out and build relationships for the company that help the company advance its business, whether it's in sales, whether it's in partnerships, vendors, otherwise. You have been paying those people to do that as part of their job. You paid for them to build those relationships. That goodwill that comes out of that those relationships belong to the employer. That's another item to be clearly addressed in offer letters for individuals who have those kinds of duties in their positions. The reason for that is an individual could leave and take their book of contacts with them and immediately start contacting or soliciting your customers or your vendors again, and have them limit their relationship with you in favor of the employee's new employer. So it's very important to lay out who owns that goodwill. And these agreements have to be supported by consideration, in other words, something of value, and limited, time limited, which they are. And again, within the public interest. That is, you can't stop ordinary competition. If you do have employees in Massachusetts and you weren't aware of this, there's good news. If you had a non-compete that was in place prior to October 1st, 2018, it's still valid because the law was not retroactive. Under the new law, one thing that's interesting, the non-compete requirement applies to both employees and independent contractors. So if you bring contractors in to help you in your business, and they are legitimate independent contractors, say an engineering firm or something to help you out in development of a particular facility, those kinds of things. If you're going to have a non-compete with them so that they don't disclose what they learned about your business, or you don't want them to help someone else build a facility based on your design, those kinds of things, you would also have to ensure that you have a valid non-competition agreement with them. The non-competition statute specifically is very clear that it is only applicable to agreements which restrict an individual's ability to seek new employment or gain new employment. Non-disclosure agreements, anti-rating agreements, non-solicitation agreements, although those are restrictive covenants, they are not limited by the statute. One of the other kinds of things that is not limited by the statute is a non-compete arising out of the sale of business. So if you purchase a business here in Massachusetts and, for any purpose, you can, in the contract of sale, have a non-competition clause with the principals of that business. You're buying the value and goodwill of that business, and you have the right through that sale process to limit the founders, say, of that business from going out and opening up a brand new shop doing the same thing next door to the business that you already purchased. Again, that would significantly harm your ability to take advantage of the goodwill that you purchased. We've talked about this. 12 months is the maximum limitation. It can be extended by a year if the employee breaches a fiduciary duty or misappropriations, takes your stuff, steals your business plans, your clients, otherwise. However, the second point about the extension of 2 years will likely be determined by a court. In other words, you would have to bring an action for breach to the court in order to get this extension. The statute is not clear on this issue, but this appears to be the way that the courts are interpreting it. This is very important. Non-competition agreements cannot be enforced in Massachusetts against non-exempt employees, and I'm going to talk about what non-exempt employees are, but these are employees who are required to be paid overtime and minimum wage for all hours they work. These folks are usually not managers, not supervisors, not executives, and not necessarily highly skilled individuals. Undergraduates and graduate students, anyone under 18, and even if you had a non-competition agreement against someone in place from the start of their employment, if the individual is terminated without cause, in other words, no conduct, no reason that required their termination, although financial exigency, in other words, if you're having layoffs because you are closing a business, that may be allowable. However, general layoffs certainly are not. So if you're laying people off with a closure, my belief is any layoff in Massachusetts is going to be seen as being a termination without cause. Then that restrictive covenant would be void. They would not have to comply with that restrictive period. I'm going to go through this very quickly. This is some just administrative information. I put this in the slide so you can refer back to it. There are some requirements that are a little bit different for agreements that are entered, non-compete agreements that are entered into at the commencement of employment and those after employment has already commenced. And they're here. You have to basically give notice to the individual. The agreement has to be in writing, has to be signed by both parties. You have to let the individual know that they actually have the right to counsel, and that you have to give them 10 days to consider. The biggest thing about non-competition agreements that are entered after a person has become an employee, is that the continuation of their employment alone is not sufficient consideration to support the agreement. In other words, you can't just say to someone, if you want to keep your job, you have to sign this agreement and follow it. That's not enough. You have to give them something else, whether it's a pay raise, whether it's additional benefits, whether it's more time off. It has to be something in excess of the continuation of their employment. Garden leave, we've talked about this, is the 50% for the period, 50% of that salary. So if you, again, have someone on a 12-month restriction, you'd wind up paying them the equivalent of 6 months of their base salary. Wage and hour issues. Wage and hour issues are significant areas of liability, particularly in Massachusetts, because the penalties for violation are severe. Failure to comply with either the Fair Labor Standards Act or the Massachusetts Wage Act. The Fair Labor Standards Act is the federal law, federal wage law. That is the base requirement under federal law for paying people for hours they work and overtime. The Massachusetts Wage Act goes beyond in its requirements for things like minimum wage is higher in Massachusetts. The conditions under which someone must be paid overtime, which is time and a half pay for any hours over 40 in a work week, are different. And Massachusetts, if there is an error or a failure to pay properly, it is automatically a triple damages award to the employee. So a $10,000 error or failure to pay becomes a $30,000 error to pay. Plus, you have to pay the individual's attorney's fees. So not only will you pay your attorney to defend you, you will pay the employee's attorney if they're successful for having represented the employee, and that is on top of the treble damages. So again, even a relatively small calculation error over a period of time can become a very, very large liability. The work week in the United States, for purposes of calculation, this doesn't have to do with how you schedule people so much. This is all for the calculation of wage and hour related issues. You as an employer can set what that week is, but that week is going to be 168 continuous hours. So typically, my clients set up a work week beginning at 12:01 a.m. on Saturday, running through 11:59 p.m. on Sunday. And again, that is for calculating things like overtime. When we say over 40 hours in a week, that week is a week that has to be established and communicated, and it has to be that 168 continuous hour period. It doesn't mean you can't have a bi-weekly pay period, but when you pay someone for a 2-week pay period, you must do the calculations for overtime individually for each of those weeks. You can't average it over the two. And what I mean by that is if somebody works 50 hours in the first week of a bi-weekly pay period, you can't then in the second week say, hey, take some time off, and you're only going to work 30 hours this week. So you level it out to 40 and 40. That would be improper and a violation of the law because the calculation applies to the single work week. The next biggest issue in wage and hour is exemption status. There are two types of employees, very simply stated, under wage and hour law. There are those who are exempt. Those are individuals who meet the legal requirements for exemption from the minimum wage and overtime requirements of wage and hour law. They're paid on a salary basis, and that salary cannot be reduced based upon the quantity or quality of their work. And right now, the minimum salary is base salary that has to be paid for someone to be exempted is $455 per week. Again, that's that 40-hour work week that we're talking about. That $455 covers that. And they can work any number of hours. For example, as an attorney, I'm considered under the law to be professionally exempt. So it doesn't matter if I work 40 hours or 70 hours this week. The only thing that I'm entitled to for pay is my salary. Whereas if I was a non-exempt employee, I'd be paid for every hour worked and paid time and a half my regular rate for all hours over 40. Again, here the employer is obligated to meet all the requirements for exemption, or to demonstrate it, not the employee. I've given you the basics here of the information about exemption status. And again, these are limited only to the exemptions that are allowable under, specifically stated under law. Misclassification, again, is where you misclassify an individual as being, say, exempt, and they were actually non-exempt. That's a violation of the law because you didn't properly categorize them. And another note is that in Massachusetts, the Massachusetts Wage and Hour Law holds the president and treasurer of a company and/or those who had management duties, who made payroll decisions, essentially, to be personally liable. So that means even if the company were to go bankrupt or out of business, the individuals would be responsible for paying any damages. I'm going to go through this very quickly. There was an amendment to the Massachusetts Equal Pay Act in the last 2 years. And again, the purpose of the Equal Pay Act is to try to ensure that women are being paid on a level that's comparable to men. And again, what happened with this amendment into the existing law in Massachusetts was to make the law a little stricter, as well as to provide some compliance points. And some of those things were to change definitions, like broadening the term of comparable work to mean work that is substantially similar in skill, effort, and responsibility, and performed under similar working conditions. Job titles mean nothing. You can call anyone anything you want them to be. The way things work under wage and hour is, what does the individual actually do when we're evaluating comparable work? You can have differentials in pay for certain approved reasons, and these are those from the statute. You know, if someone has been somewhere longer and therefore has achieved raises over years in their salary, that's appropriate. If a salesperson is making more money than another salesperson because they're selling more, on its face, that's okay. There is a safe harbor for penalties under the statute. If an employer in Massachusetts conducts a pay audit, you can get an affirmative defense to claims after having done the audit, and you can limit your exposure to penalties. One thing that I would say with the Massachusetts Equal Pay Act, with the pay equity as being an opportunity for employers to reduce their potential liability, is that there is also a federal Equal Pay Act that does not provide protection through such an audit. In Massachusetts, the statute says that the audit will not be held against an employer if they've done one. The amount of protection they can get from penalties is limited if they did a bad one, but the fact that you made a good faith effort and it came with a reasonable determinations concerning corrections to any disparities in pay between men and women, you get protection, and that pay audit that you create cannot be entered in court as evidence of anything. However, the federal law doesn't provide that protection, meaning that if you create this pay audit and there's a claim brought under the federal law, that pay audit, which may disclose or identify many problems with your pay program, could be used against you as evidence in the federal court. Simply put, I recommend that you have an attorney assist you and to work with you on determining the scope of such a report, and also on advising you on how to conduct it. The reason for this is you can get the benefit of the protection in Massachusetts, and you can get the benefit of being able to claim that the audit is privileged as attorney-client communication, and as being created on the advice of counsel, which means that you can protect yourself from that audit being disclosed in a federal court case. Leaves of absence and disability accommodation. I'm going to go through these quickly. There are many statutes, and I know for individuals who are in Europe and elsewhere, this seems very strange sometimes because there are public and statutory benefits that apply to everyone in different countries. So there's no need for such laws applicable to specific employers, but in the US, this is the way it happens. If there isn't a law that requires a particular kind of leave, then it's at the discretion of the employer to provide it. These are some of the statutes that I put out here, and I've given you the minimum number of employees that are required for the statute to apply. Where you see that there is no number of employees, like the Massachusetts Earned Sick Time Law, it means it applies to all employees in some manner. The ADA and the 151B is a Massachusetts statute that would require accommodations, including potential leaves of absence for individuals with disabilities. That's why you see them both there. The Earned Sick Time Law in Massachusetts is that individuals, and this is a minimum requirement, is that for every 30 hours worked, an individual will accrue 1 hour of sick time up to a maximum of 40 hours per year that they can use. And sick time can be used, and it's a job protected leave. In other words, the individuals cannot be prevented from reasonably using this sick time and being paid for it by the employer. If the individual has the time accrued and they are going out for one of these reasons for using sick time, you have to let them go. There is a similar statute for domestic violence leave to help individuals who may be trying to, again, this is outside of the employment relationship, but under public policy, the state of Massachusetts wants to assist individuals who may be living in a violent domestic situation so that they can get time off from work to be able to obtain assistance, as well as for the protection of the courts without potentially losing their jobs for trying to go do so by being absent from work. Massachusetts parental leave used to be only maternity leave. Now it applies to men and women equally, and it's for 8 weeks of parental leave for birth, adoption, or placement of child. The Small Necessities Leave Act is a maximum amount of leave of 24 hours to participate in things in like school meetings, go to school plays, to go to doctor's visits with your child. That is another statutory leave here in Massachusetts. The Family Medical Leave Act is a federal leave law that has a minimum base that allows individuals up to 12 weeks of unpaid leave. The employer can choose to pay it for serious health conditions or for bonding with a new family member, such as someone who's adopted or a child being born. And that's 12 weeks over the course of a 12-month period. Reasonable accommodations, again, as I said, this is for addressing individuals who may have disabilities, which might inhibit their ability to come to work. For example, someone who's undergoing cancer treatments, cancer would be considered to be a disability under law, and the individual may need a leave of absence in order to receive treatments and to recover for treatments. That would be something that would be essentially a required example of a required accommodation under the disability laws. I've given you some information about the process for engaging in discussions and dialogue concerning reasonable accommodations. One point to note for employers is that the requested accommodation is not what has to be approved by the employer. The employer only needs to provide an effective accommodation. So if a person wants to have 6 weeks off and there's only a need for 3 weeks of treatment, they don't have to approve the 6, they can do the 3. You don't have to accommodate someone who's a threat, even if it is as a result of their disability. If you have someone who might have a mental illness and they're making threats to individuals, or being inappropriate in the workplace, the fact that they have a disability does not excuse the behavior, nor does it excuse breach of consistently applied policies. Massachusetts just this year has created its own Similar Leave Act. However, the biggest thing to know about this for a company that's coming here is that this is a paid leave program that covers many of the same reasons that individuals could get protected leave under the federal law. The individuals, both the employers and employees will essentially have a tax on payroll earnings to a capped amount each year that will go into a fund which will operate like unemployment benefits here in Massachusetts for the individual to receive some pay during periods of time that they are on an authorized leave under the statute. I give you much of the background information as to what is covered, how long an individual can take leave. And this includes all employers. Again, there's no minimum number of employees here. It's whether or not you have at least one person who's receiving earnings through employment with you, including independent contractors. Employers can create a private plan option for themselves to provide employment benefits, and so long as they are providing benefits that are at least to the level of what the state would provide under the program, then they would not have to contribute the taxes. They could just set their own program up through a leave and benefit program and operate it. There are, of course, penalties, which can be significant. I've listed them out here for you. Business and employment-related immigration. I'm going to go over this very, very quickly for the things that people usually want to know. The H-1B and the B programs, the business immigration programs, are the ones that my clients have the most questions about. The important thing to remember about immigration is kind of two different tracks. There is a track for someone who just simply needs a visa to come and do business in the United States, but not necessarily to get a green card or become a citizen. The visa programs are very clearly delineated, and in most cases, prep work needs to be done in order to obtain the visa in the country of origin. So if you were coming from Norway to come to work in Boston, Norway is a trade country with the United States. We have trade agreements that you could come for a business purpose, a specific business purpose, for a short period of time on a visa and not need to go through the full immigration or green card process. If you see here, you'll see the B1 program here. There's a foreign business visitors for purposes of conferring with colleagues, attending seminars and other activities, for purposes of purchasing a business, for purposes of coming over and monitoring or supervising a business for a period of time. But again, they are time limited. L1s for transfers of executives, managers, and employees with specialized knowledge from a related company abroad. If you have a holding company or a parent company in Europe and you have an entity here in Massachusetts, you can use the L1 visa program to move people back and forth between the two. There also has to be a component of American ownership in the company as well. I've talked a bit about prohibitions of discrimination and harassment. There are several laws that prohibit, again, discrimination on the basis of an individual's personal characteristics, their nationality, their national origin, sexual orientation, marital status, color, religion, all of these issues. Title VII is the federal law, which covers anywhere you go in the United States. 151B is the anti-discrimination law here in Massachusetts. The ADA is the federal disability law, which we've been talking about a little bit. And the MCRA is the Massachusetts Civil Rights Act. Under all of these statutes, where an employer engages in discriminatory conduct, which is making decisions about an individual's employment or the terms and conditions of their employment, including benefits, pay, working conditions, based upon a protected characteristic, and here are examples of protected characteristics, are subject to liability through civil lawsuits, which in Massachusetts, the damages for those lawsuits technically could be uncapped. A jury would decide how much of an award of damages could be given against an employer. That includes what we call back pay. In other words, if the person was terminated because of on the basis of race, let's say, then you'd have to pay them all the way back from the date of termination through the end of trial. There's also front pay, which usually goes with age discrimination claims, where it might be more difficult for someone to find a job because of their age. You may have to pay them for a period of time to look, as well as other kinds of damages, which can be uncapped, things like emotional distress damages or related consequential damages. And a jury, again, the damages are uncapped in Massachusetts. So if a jury believes that you behave particularly inappropriately, that they can award millions of dollars in damages. Two basic types of discrimination, and one is disparate treatment. That's where you actually make a decision or take an action against some protected characteristic. Harassment in the workplace is where no one terminates someone or cuts their pay or doesn't give them a raise or doesn't provide them an opportunity. Those are the kinds of disparate treatment. But they make the work environment so hostile based on an individual's, say, race or religion or their gender that it impacts their ability to work. And this is an example where it says, we're talking about sexual harassment, but you could replace the word sexual with any of the other protected characteristics, and the application of the law would be the same, whether it's color, race, creed, religion. If basically someone is being subjected to intimidating, hostile, humiliating, or offensive treatment or conduct in the workplace based upon their status as a member of a protected category, then that could, in and of itself, bring liability to the employer. And it is critical in Massachusetts that supervisors and managers, as well as employees, be trained and understand their obligations here. In Massachusetts, the law is that if a supervisor or a manager, in other words, a person who has authority, whether formal or informal, to address issues of workplace conduct, is aware of the discriminatory behavior, liability is established for the employer. You can't say that you didn't know about it. Massachusetts holds supervisors, managers, owners to be agents of the same organization, so that if a lower level supervisor engages in race discrimination, it's as if the CEO did as well. The company itself has done it. Finally, you cannot retaliate against any person for, again, we talked about this up front, about pursuing their rights to be free from discrimination. And retaliation is a separate claim or separate violation of law which can bring additional damages. That's presentation for this morning. I know that I went through some areas fairly quickly. I am more than happy to take questions and to arrange to do so beyond the time that we have today if necessary. But these, again, are basic issues that employers coming to Massachusetts should consider and should at least research and understand in order to operate effectively and efficiently in Massachusetts. Thank you.
Ryan, thank you so much. And thank you, everybody, for joining us today. I hope you found it informative. There was a lot of information presented, so you do have this as a recorded webinar to go back and look through at your convenience. There is one question that I'd like to pose here, and can you speak a little bit about independent contractors paid on a retainer? Where does that fall?
Paid on a retainer.
In other words, if a person was hired in as an independent contractor, but paid a certain amount of money per month to be able to handle problems that came up related to whatever they were hired to do.
Right, and I think that's a good question, but stay simply in the structure of independent contractor first, is that, for example, I would be an independent contractor to your company in a way, in that you bring me in to provide you advice and guidance on legal issues, but doing so is not the nature of your business, right? If you pay me a retainer for those services and I am truly an independent contractor, that's fine. That's an independent agreement between two businesses. Essentially, I'm an entrepreneur. I have services to provide you. I provide those services in a business of my own. It's a matter of contract between us as to how and how much we get paid. However, one of the areas that I've seen come up quite a bit is things like IT services, where a company, say a finance, an accounting firm, they rely on their software, they rely on their hardware, they rely on their networks. And they have someone who does that work. They have a help desk person and they have a director of IT. And the director of IT decides, well, I know that there's a person who's really good at, working with a particular software program that we have for our accountants. So when we have problems, I'm going to bring that person in to train and teach people and to modify the software, whether they're creating crystal reports, something like that. That's an area where you can get into problems, because if it's just someone that the individual knows, not a company, they're not outsourcing to a real IT company that has its own business or otherwise, they just have their friend who's going to be doing it because they know how, or they're unemployed and they're trying to help them out. That individual would likely be your employee, not an independent contractor, which means that you would have to have paid that person correctly, either the salary or the hourly wage required. So if you happen to pay them on a retainer, that might be okay, so long as the retainer is sufficient to cover their expenses as an employee for the amount of time they work for you. So what I'm saying is, if you only put them on a retainer for $1,000 and it's equivalent to paying someone $10 an hour, and they worked 20 hours for you or 100 hours for you, that you would have underpaid them. And as an independent contractor, that you could be sued, or the state could bring an action against you for not having complied with the wage and hour laws with respect to that individual. I hope that was clear.
Yep, clear. Thank you. That's important. Are there any other questions from our participants today? I don't see any. I think we've exceeded our time now, so we'll let people go. But I just want to make one announcement of our next webinar, which will be held on November 14th at 9 a.m. And the topic for that day is Perfect Pitch for U.S. Investors. It's going to be given by Linda Plano, whose company is Plano and Simple. You can find that on our website. So thank you, everyone, for joining today. And please do contact Brian if you have any further questions. His email is on the final slide. Have a great day.